Okay, I should be live now. Today we're doing something a little bit different. Obviously involving the Vic situation. Just gonna real quick. Let me just move that over here. So we're just gonna look at the filing for, of course, the TCPA. So this is what we're gonna do. We're gonna read through this 1,188 document for our own amusement. Sorry you guys won't see most of the stuff here. Unfortunately, it works. Unfortunately, it's not my problem. So you already see these tabs here. Let me just close this down. Don't really need that up at the moment. I will need voice mode up. So we're gonna look through this document right here. That's it. Yeah, for my amusement, because I'm going to fucking laugh at this. Because it's quite spicy, as I've heard. So obviously we've got the case number and all that stuff. So we've got Nyana versus Funimation Productions, LLC, Jamie Markey, Monica Real, and Toyo. On the 41st Judicial Court of County, Texas. So this is the plaintiff's response to defendant's TCPA motions to dismiss. I'm fine. Bit lurgy. Maybe having a bit of a cold coming up, so hence why I'm trying to do this now while we got it here. To the Honourable Judge of said court. In this response to defendant's motion to dismiss, plaintiff Victor Mignana, Vic, objects to defendant's evidence shows they fail to meet their burdens, meet his burden, and the request that the court strike the defendant's evidence and deny their motions to dismiss. Lol. Number 1. Background facts. For years, the work environment at Funimation Productions LLC was amorous and sexually charged. See Monica's deposition. Its programming is still salacious or sexual, such as Panty and Stocking Forgot About, starring Jamie Markey or Soraya as Panty and Monica Real as Stocking, a show all about sex and eating candy, and two fallen angels dressed as schoolgirls who use their lingerie as weapons to fight bad guys. See number 2 is of course the Funimation shows Panty and Stocking Forgot About and the Tilda Anime Expo 2012 of Panty and Stocking, both last checked on August 30th of this year. So they have backtracked quite a bit. I haven't. Beware, sorry you guys can't see chat. Mob Crush it. I don't know what's going on. I'm just gonna close that. But no, I can see chat. I can see chat. I think OBS is being a bit silly today. I think it's been silly for quite a while. Don't know why it's doing that. I think I may need to check it again. So apologies, you guys won't be able to see your chat. Fortunately, it's how it works. And prison school, where the school is ruled by a secret council of sadistic female students, and boys are in for a world of hurt. A super raunchy anime series and the most perverted anime show. See citation 3. The Funimation shows Prison School and the ranker dirty anime that is still really raunchy. by Leon Arena, and of course the top 10's Pervert Animated Show, all are checked on the 30th of August. Ooh, let's skip a bit. Oh dear god, now you're going to see all these images. Oh, this is going to be fantastic. As Times Funimation uses provocative imagery to show as Jamie and Monica in this promotion, Figure 1, for the show Panty and Stocking with Garter Belt. Garter Belt is voiced by Christopher fucking Sabat. Oh, you'll see in a minute, Brandon. Trust me. In fact, this raunchy environment at times appears at conventions attended by its voice actors. For example, Jamie Markey making out with Victor Mignogna, of course, with J. Michael Tatum present. Figures 2 and 3. At the 2010 Konnichiwa convention in Tucson, Arizona, or Monica being spanked, the 2011 Anime Detour convention in Minneapolis, Minnesota. Figure 4. Rumors of Vic being an asshole, using fans, and being a pedophile were begun by Funimation's de facto, and thank you for the host, Super Saiyan 4 Viking, de facto manager Christopher Robin Sabat, Monica Rial, and Jimmy Markey in the early 2000s. Of course, we got Ronald Toyo's deposition right here for number 4. And of course, which I believe is somewhere around here. There it is. Number 4 right there. We do have them 6, which of course is a Twitter post made by Game Wizard, last checked. And of course, the YouTube link for figure 4. True, but thing is, Verb is owned by Crunchyroll. Technically. It's owned by the same company that owns Crunchyroll, and I believe also Rooster Teeth. Page 3. Long before any posts or tweets cited by defendants were made, citation 4, from 7, Funimation nevertheless points to the January 16th, 2019 tweet by Han Leia, citation 8, tagging it with the question, "Hey Funimation, why do you employ a known pedophile?" and linking to a post on Pretty Ugly Little Liars. Should have really put an S there, Ty. It's Pretty Ugly Little Liars. Not Pretty Ugly Little Liar. Inciting allegations against Vic and triggering its investigation. Citation 9. But Han Leia did not state that Vic is a known pedophile, and Vic has never been charged as such. Citation 10. Indeed, on January 18, 2019, Marsgard posted, "Hey, I just want to be certain it's possible that you were remembering the voice actor Ila Godora?" So Marsgard referred to Ila Godora, but she still started the movement. Bruh, bruh, bruh. Super Saiyan Blue is part of the free updates. You have to max out the friendship with Whis in order to get Super Saiyan Blue evolved. You have to max out your friendship with Vegeta. Just do tons of PQs with him. It'll be fun. Referring to a different former Funimation actor, not Vic, had been the one charged with sexually assaulting a minor. Technically, he married her in Las Vegas with her mother's consent. On January 20th, Vic tweeted unequivocal denials of Han Leia's charges and sincerely apologized to anyone who thought he had been less than kind and grateful, or whom he had made feel badly or uncomfortable. He finished with a clear statement as possible. Finally, any allegations of sexual harassment, sexual assault, or most disturbingly pedophilia are completely and utterly false. My heart weeps for anyone who endures a violation of this kind. So, to be accused of harming others this way, I have no words. The citations needed. Not to fuck up. Probably not to fuck up. I like how you guys are ignoring me and just having your own little casual conversations while I'm currently reading a massive fucking document. God damn it. Okay, so we got citation 7 being Chuck Huber affidavit. We got citation 8, the anonymous Twitter handle for Caitlin at Leon. I have feelings for you. See Hanlea last checked on Thursday. Good. Yeah, because since Nick's not around, I might as well try and do it as fast as I can. But and of course, citation 9. Funimation's notion at page 2, the affidavit of Tammy Denbo, attached to Funimation's motion at paragraphs 154. Fidelity Lie is a self-proclaimed censorship-free forum. See fidelitylie.net. On January 16th, Monica lied and republished another tweet by Hanlea, which accused Vic of being a homophobic, rude asshole who was being creepy to underage female fans for over 10 years. Plaintiffs amended petition. However, Funimation does not claim its investigation involved in its latter tweet. Okay. Number 10, Vic's deposition. So we're gonna look at Huber's affidavit, because that'll be interesting. Vic's deposition, we're not going to look at. Monica Rial's deposition, we're not going to look at. And Ron Toy's, we're not going to look at. The reason why is because obviously they're the ones that can take out the big chunk of this. So what we're going to be doing is we're going to skip all that. There are video ones on Nick's stream. So if you guys want to go watch Nick Creator after this, I would humbly do so. Ron Toy's, I believe, is in 2 parts. Vic Mignon's is in 4, and of course Monica's is 1, because hers was the shortest. Okay, citation 11, obviously Bumpity Gone Like a Lad, M plays drama teacher who married a 16-year-old girl, faces charges, which of course is Error. So then there'll be actually linked there. And then we got Shannon McCormick sexually some Huffington Post by S. McCormick. And of course then we got Lindsay Loveridge, also called her Lindsay Cottage. Sexual assault charges are dropped against voice actor Ila Corolla. Back in 2014, you cannot deter from who is who, you bitch. You mean Crow? This one. Learn a spell. That's what the Crow spell. And of course we got citation 11. Well, citation 12. Funimation's Motions, page 3. A 20-year veteran of anime voice actor industry, Chuck Huber, also was not aware of any accusations or rumors that Vic had sexually assaulted any or harassed anyone prior to the defendants. Okay. Yeah, I just spelled the name for you. It's with a Q. Okay, Cap, fine. You only have like 10 minutes. Let's face it, all the SJWs know how to dodge, deflect, and fight. A few days later, on January 22nd, Ronald began phoning and tweeting Christopher Slatosh, a host of ChimeraCon convention. Ronald accused Vic of assaulting 4 people, Monica, the 2 twins who lived with me, being the Yost twins, and another voice actor's girlfriend. Told Slatosh that Sony was conducting an investigation and that criminal charges would soon be filed against Vic. Citation 13. Monica also phoned Slatosh and called Vic a sexual predator, and repeatedly asserted that criminal charges would soon be filed against him. Citation 14. During the telephone conversations, Monica and Ronald both urged Slatosh to breach his contract with Vic, despite his explanation that doing so would breach his written contract with Vic, and refused to continue to do business with Vic in the future. Citation 15. However, I have something interesting about the ChimeraCon, especially in the next one. Ronald threatened that Monica would cancel her appearance at ChimeraCon and that his company would withdraw his financial censorship of the convention. Monica likewise threatened to convince other voice actors to cancel their appearances at ChimeraCon if Slatosh did not breach his written contract with Vic. Citation 16. Due to Ronald's disclosure of the Sony's investigations and Monica's pressure, Slatosh cancelled Vic's appearance at ChimeraCon in a breach of his written agreement. Citation 17. Slatosh eventually re-invited Vic to attend ChimeraCon, but only after a considerable expense. Claims Huber affidavit, lines 52 to 57, 16, 1 to 62, and 81. Affidavit from Clay Slatosh, paragraph 67. Paragraph 9, Jamie Lee and Monica told Chuck Humer that criminal charges would be filed against Vic. Humer affidavit, paragraph 79, line 79. Slatosh affidavit, lines 7, 9, 12, and 16. Through 9 to 11 and 13 and Exhibit B. 3 and 4 of ChimeraCon was not only the convention to cancel due to the defendant's pressure. In fact, until the defendants began defaming him, Vic had never had a convention cancel his appearance. Vic's affidavit. I know he did. By both sides are requiring Vic to pay for additional security, but something not required other than of other guests. Citation 18. Monica made good on her threat. Citation 19. On January 23rd, Monica and Tammy Dembo, a Sony employee, exchanged an email which Monica thanks her for making her feel at ease and helping me realize it wasn't anything I did wrong, and Tammy Dembo is glad to help to talk it through. On January 24th, Ronald tweeted at, I know 100% certainty that Vic assaulted 4 people that I love. Citation 20. On January 25th, Dembo contacted Vic. Funimation was conducting a confidential investigation into Vic's writing Monica's name on a jelly bean she threw to him at a convention, not at Funimation's offices, and then eating it. Citation 21. His flirting with 2 adult women at a convention, not at Funimation's offices, who had been flirting with him for more than a year. Citation 22. And a single consensual kiss between Vic and a co-worker more than 3 years ago at Funimation's offices, which no complaint was ever made. Citation 23. There was no allegation of abuse, assault, or harassment. Citation 24. That day, Ronald tweeted, Vic assaulted 4 people very close to me. Citation 25. Lines 14, 11, 15. Ronald's deposition. 36, 45, 38, 20. Ronald's deposition, Exhibit 28. Monica testified that this jelly bean took incident like 15 years ago. Monica's deposition, 33, 6 to 13. Vic testified that this occurred several years ago. Page 26, lines 15 to 17. testified that this occurred in 2015 or 2016. Page 128, 15 to 18. Vic's affidavit, Monica and Ron's motion, Exhibit 24. Compare Funimation's motion, page 4. Affidavit of Tammy Dembo attached Funimation's motion, lines 1 through 4. Chuck Huber was also told that Funimation's investigation was confidential. Huber affidavit, line 82. Ron's deposition, Exhibit 28. That's fine, that's fine. Chat's not working at the moment. Right now it's being funny, so I'm just showing up Twitch's side, not the others. Which I find weird. Okay, let me just go on to the rest of it. On January 26th, Ronald declared that Vic is guilty of sexual assault and that Vic is a predator. Citation 26. 2 days later, January 28th, Ronald publicly stated that Vic is a man of a clear history of sexual deviancy. Citation 27. The next day, January 29th, Funimation informed Vic that his contract with Funimation was terminated and gave him no reason for the termination. Last citation 28. On January 30th, Monica emailed Demavere thanking her for the 29th voicemail update and for being so kind. Monica also exchanged six emails with Lisa Gibson that day, during which Monica asked Gibson that she would say publicly, broached when Funimation would make a statement, and thanked Gibson for her update. And Gibson encouraged Monica to hang in there. On January 31st, Monica had a telephone call with Gibson and Sony's Scott Barretto. Scott Barretto is Funimation. Ty! You fucked up! And Ronald tweeted, I know at least 4 assaults, and I'm glad to see conventions Kansas that now the truth is coming to light. Yeah, sure. Citation 30. 3 days after her telephone calls with Funimation executives Gibson and Scott Barretto were referred, so Monica mirrored Ronald's language, and when she tweeted, the truth will come out. That day, Vic publicly denied his detractors' allegations. At line 32, also line 31. Wasting no time, on the February 4th, Ronald mocked Vic's apologies and publicly claimed, I know without question. He heard people very close to me. Those tears are fake. Line 33. Ronald's deposition. Funimation's motion, Tammy Dembo's affidavit. Exhibit attached here too, which of course is language used for Lemoy and Jason Lemoy and Casey Eric. Ronald's deposition, Exhibit 28. Exhibit Monica's tweet went to Morphbox and DBZ UK Comedy House. The YouTube video last checked on the 29th of August. Chuck Huber likewise notes that the voice actors often hug fans at conventions, regardless of age, and he always saw Vic stopped if someone acted like they did not want to be hugged or kissed. Huber affidavit lines 65 and 79. It's becoming hell. Right. He then declared there were over 100 ladies and counting coming forward with accusations against Vic. Citation 34. The next day, February 5th, Ronald publicly called with Funimation to make a public statement about Vic and for Vic to be banned indefinitely. Citation 35. Again, publicly calling Vic a predator. On February 6th, Ronald again publicly accused Vic of assaulting my fiance and declared that there were over 1,100 accounts of assault. He made it clear that the objective was Vic being blacklisted and out of work, and predicted that the proof of the allegations against Vic would be him getting fired from everything. The next day, February 7th, an email to Funimation's Team Simon, Monica accused Vic of sexually assaulting her in 2007. As if synchronized, Jamie tweeted the same day that Vic is a monster and there are dozens of reports. And Ronald again publicly called on Funimation to make a statement. Jamie then reveals their plan: use name and shame to destroy Vic's reputation. Yeah, to fucking kill him, you fucking bitch. Am I not wrong? They wanted him fucking dead. They wanted him to hang himself. They wanted him to off himself. This is why he's taking antidepressants, folks. That's why he's lost quite a bit of weight. Ronald's deposition. Deposition. Y'all. Jamie's tweet. Deposition. And of course, Jamie's famous "I want his balls" quote. On February 8th, Vic tweeted that he did not want anyone claiming to support him making threats. Let me be perfectly clear. I would never condone anything approaching to this whatsoever, and I will call upon anyone doing it to stop this immediately. That same day, Monica and Funimation's Colin Clankenbeard mocked Vic for his private email to Monica, explaining that he had always considered her a dear friend, and asked her to tell him what he had done wrong to make her so angry. The next day, February 9th, Jamie tweeted that Vic assaulted her, and she could not remember when, by grabbing her hair and whispering something in her ear that she could not remember, then stating Vic had done this exact thing to half a dozen other women that I personally know, and that he is a predator. 2 days later, February 11th, Funimation tweeted, "Following an investigation, Funimation will no longer engage in manana future productions. We do not condone any kind of harassment or threatening behavior being directed to anyone." Monica added to Funimation's tweet, "There were more investigations with testimony, proof, evidence. I am one of the dozens of men and women who participated." Yeah, fucking right, it was just you, you lying bitch. It was just you. You just basically spewed shit down Tammy Dembo's throat. Because you were being a lying bitch. I've never watched the movie. Right now, we're talking about the fucking document. Brandon, you're not even listening, are you? Stop, Lux. Haven't. But also remember, Monica responded to my friend, Clever Fox Soul. With that tweet. Because Monica should have been fucking fired also. And now she's probably going to get more fired. Not by Funimation, but probably by Sony. 38 heads are going to fucking roll, Monica. You brought this on them. I can literally name every single voice actor who's on the chopping block with you. And I'll happily even draw the chopping blocks and put all your names on there. You know what's even more hilarious? I don't even use my wallet that you've signed. I don't even use it anymore. It's now a reminder that you just want the fucking money. You just want the power. Because Vic was going to be a director of Funimation. He was actually going to be an actual employee. But no. You, Sabbath, Marky, you all wanted to fucking put the noose around his neck and let him have an attempted suicide. You self-deluded cunt. Funimation's Twitter followers knew exactly what Funimation was saying. The result of his investigation was that Vic engaged in harassment or threatening behavior. Funimation's Motions page 5. Here to Real first on the first page. Here to Jamie Markey's tweet. I believe that is the 8th of February. However, in her recent affidavit, she suddenly remembers that this event occurred approximately 2011. Why didn't you mention it before? Be glad I'm not screaming. Because I've got the lurgies. So I can't really do that right now. But still does not remember what Vic allegedly whispered in her ear. Ooh, the irony! Jamie's motion affidavit of Jamie Markey, line 2. Funimation's motion, Exhibit L, Monica's rapid deposition, Exhibit 31, and plaintiff's motion at line 30. Monica's deposition, page Exhibit 31. Particularly since Monica has reinforced with her description of multiple investigations with testimony and proof and evidence. Blah 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 blah. Oddly, Funimation has never contradicted or corrected Monica's signal boosting. You also need to realize Barbara means condom, right? You'll be beating them with a condom. They're probably gonna need it. Because Ty's going in raw. Don't. Right. Let me make this perfectly clear. I don't want you guys to go harass these guys. Right? Whatever they say, whatever they do on Facebook, Twitter, Instagram, any form of social media, ignore it. Also, if you're on YouTube, open up a tab, go back into YouTube, type in Vic Mignogna's WoW video, and subscribe to him. That, or you can basically, link Monica this stream, because I'd like to have a word with her. Hey, viewers. We're just going through our 1,180 document. We don't know yet, because right now, Funimation, they're currently in two very different locations. Toei and Funny are also in Japan, and also they're in Crunchyroll Expo. They're fucked either way. 2 days later, February 13th, Vic tweeted that he had no idea that any animosity turned towards him had existed until these last 3 weeks, and apologized if he had made anyone feel uncomfortable, and begged for people to please be kind to one another. The very last thing I want for anyone to be is hatefully targeted, especially not on my behalf. Oh yeah, we know that. This is why we're going through the document right now. I mean, that was a joke! Don't actually get a fucking Monica! As pissed as I am at her, link it to her fucking underling BT underdog BT. Link it to Brian. I happily talk to that black son of a bitch. Anyways, all done. Lol. Nah. Because I already know that Scott Sporato is watching. Hey, Scott. You're fucked. Well done putting that tweet out. Everyone knew what was going on. You're just being incredibly vague. The timing was piss fucking poor. You should have done it when he was actually terminated. You complete dick. And you all have got a fucking heads up your own asses fucking masturbating to the joy of it. Eat shit and die. See? Ever since this stuff escalated, I only bought one Funimation product. The thing is, that was back when it was manga entertainment. And now that manga entertainment has been bought out by Funimation, I'm no longer buying your products, and I'm not subscribing to you. So, how about you get your heads out of your fucking arseholes, see reality, because you're gonna fucking need it before this litigation ends, or when we get to September the fucking 6th, and say just settle. Because if Jason on the morning wants to get it on for 12 more months, not gonna fucking happen. Ty's gonna slaughter you more than the scene with Sebastian Michaelis against the zombies in the Titanic. If you watched Book of Circus. And I know you have Brianna Palencia, J. Michael Tatum, Monica Rial, Jason Lieberich. You've all fucking watched it. Because there was that scene in particular. You incompetent pricks. It's from Black Butler, Book of the Atlantic. It was a movie that came out like a couple of years ago. I've got the DVD for it. I also have it in the manga. Right then. On February 16th, Ronald tweeted that Vic would be a registered sex offender. Never happened. Not that I can recall. 2 days later, February 18th, he confirmed that Monica was a Funimation employee. Well done, dumbass! Well done! The next day, Monica tweeted that Vic had been accused of sexual harassment, alleged Vic had grabbed her by the hair and whispered in her ear without recording what he said, and claimed that she witnessed him do it to so many people. Yeah, he did it when they piled the thing. It was for a fucking joke. Bruh. She claimed that he force-kissed her in the mid-2000s and called him a predator, which has been debunked by Stan Darlin. A Zubicon of 2007. Later, in her deposition, her motion dismissed, Monica expanded on her forced kiss story, claiming Vic invited her to his hotel room, threw her onto his bed, and forcibly kissed her, and that Stan Gatlin witnessed her leaving Vic's hotel room. Both Vic and Mr. Darling expressly deny Monica's allegations. Hey Hubert, we're just going to go through the document. Obviously, Hubert affidavit. Second boosting means posting to a community forum, mainly social networks like discussion boards, and helps gain more attention for an event or cause. This is not the primary or first announcement, but rather one of the many auxiliary posts or cross posts to the communities with individuals who are likely to take interest. See the Urban Dictionary for singular boosting. Well done, Die! Gag! Fucking love you, Die. He cited Urban Dictionary. That's gonna be funny. When they read the rest of Urban Dictionary. Gag. Animations motion at page 7. Ron's deposition at 28. Monica's and Ronald's motion at line 20. Monica's deposition at page 31, line 1 through to 8. Vic's affidavit and affidavits done down. No! No! Why the fuck you lying? Why you always lying? Oh my god, stop fucking lying! I could still sing. Darling. Oh, hello. Um. I'll reply to Steve in a second. So, on February 19th, Ronald suddenly switched from calling Vic a predator, registered sex offender, and accusing him of sexual assault and harassment to towing the line that Funimation would henceforth use. Vic had been terminated by Funimation for inappropriate conduct. Citation 58. Number 2. Objections, special exceptions, and motion to strike. Vic incorporates his objections to defendant's evidence attached to. I do have some song covers coming out. I need to do one more rap cover. Actually, I may need to do 2 rap covers. I just need to do an artwork for one. Because I am going to release Without Me, and I am going to release Venom. So that one's going to be great. And then there'll be 2 non-Eminem songs. One called Bye Bye Babylon, and the other called Legends Never Die. Number 3. Response to defendant's motions. Defendant's motions to dismiss initiated as a 3-step process. First, each defendant has initial burden to show by preponderance of evidence that Vic claims against it, her, and him are based on, related to, or in response to the defendant's exercise of the right of free speech, the right to the petition, or the right of association. Texas Civil Procedure Code 27.005b in the Minsky 406 SW3-595887, Texas 2015. I like how I'm able to do that so fluidly. Take a deep breath, Neil. If you can. Okay? Take a deep breath. We're all mad. We're all mad here. A preponderance of evidence means the greater weight and degree of corporate evidence creates a reasonable belief in the truth of the matter. Veteran vs. Common Health System 52 SW3696-706, Texas application not on Road 2008, petition denied. Rick denied November the 5th, 2018. So that one's actually quite recent. Okay then. Hey Monica, why the fuck you lying? Why you always lying? Oh my god. Stop fucking lying. Hello Leo. Welcome to the stream. We're not even a temple away there. The court considers the lie pleadings as well as supporting and opposing affidavits stating the facts which the claims are based on Texas Civil Litigation Act 27.006. Hence, each defendant must show it is more than likely not based on the pleadings and affidavits that the claims against it, her, him, are based on, related to, or in response to the defendant's exercise the right protected by the TCPA. Alan Lipinski, 460 SW3D at 589, Batra 652 W3D at 706. Whether the TCPA applies this threshold question, Bavarian vs. Beard 653 SW3D 33999 404, Texas application 412-2008, petition 9. The court must first ascertain that the rights of the defendant claims that the constitutional rights protected by the First Amendment as rules the position defined in the TCPA that the legal action was brought to an immediate or silence the defendant's expression of those rights in a matter of public concern. Universal Plant Services Incorporated versus Restaurant Group Incorporated 571 SW3D 346 558 Texas Litigation Houston 1st District 2008. No petition. If a defendant cannot satisfy its burden, its motion must be denied. Diamond Consortium Incorporated versus Hammervold 773 Federal Apex 551 154 5th Circuit 2008. Reg denied 2 4th 2018. Donald Rogers 08 17 0067 CVE 2019 WL 289 7489 at 4 Texas application El Paso July 5th 2019. No petition. In Re-Intelleccentrics Incorporated, I'm just going to skip the rest. I can't remember to read all that again. If a defendant satisfies this burden, Vic must establish a prima facie case for each essential element of his claim against the defendant by clear and specific evidence. Texas Civilization Redeem Code 2075C in Lubitsky. Money and power. Envy's a greedy bitch. It's all about jealousy. It's all about envy. Envy has always been the first sin and likes to pull the strings behind the scenes. But when the others are having fun together, it's always alone. To wallow, to spread. Because that's how envy works. The requirement of a prima facie case means Vic must produce the minimum quantum of evidence that is necessary to support a rational inference that the allegation and the fact is true. Salzburn News Incorporated versus Hall. Weber versus Fernandez. Clear and specific answers is not heightened evidentiary standard, rather it means that Vic must provide. And thank you for the follow. Not funny verse. But must provide enough detail to show the factual basis for his claim and support a rational inference that the allegation of the fact is true. Lubitsky. Vic is not required to provide direct evidence. Diamond Consortium. I know, right? Got out of that. And funny thing is, apparently I've been hearing that Funimation's been claiming all those videos that had those recordings. Hey, Funimation, how come you didn't claim mine? Is it because apparently you'll lose? Considering I was playing games at the exact same time? You fucking cowards! And also the fact that I was playing music as well? Better next time, bitch! The Supreme Court has expressly disapproved interpretations of the TCPA that require direct evidence of each essential element of the underlying claim to avoid dismissal, and instead has held that pleadings and evidence that establish the facts necessary to support the essential elements of a claim are sufficient to resist a TCPA motion to dismiss. Universal Plan Services. Lol. He may rely on circumstantial evidence if the inference drawn is reasonable. This is why we had the Ocean dub here in the UK. So Peter Calamus was technically my Goku. And he follows me on Twitter. And let's just say the rumor about the whole Goku Black thing may get debunked, considering that, Peter said something last year, and I was present. Sorry, Danny. I know a little bit more than you do on that front. Don't actually clip this shit. Jesus. I know Funimation's watching. Hi, Scott. Paul and Boeing. At this stage of proceedings, the court presumes the truth of Bick's assertions. The magazine partners LP versus Rosenthal, Greg denied, views the pleadings and the evidence in light most favorable to him. Darren Consortium, Global Plant Services, Ruger versus Swinford, and favors the conclusion that his claims are not predicated on the protection of protected expression. Bering. Okay. Oh, no doubt. Yeah, don't actually clip my shit. Unless I ask, which I haven't yet. If Vic satisfies his burden, the court must dismiss a claim if the defendant can establish each essential element of a valid defense to that claim by preponderance of the evidence. Section 70 Litigation Procedure 27.005 Hall. Number 8. Defendant's communications are not subject to the TCPA's protections. The TCPA's purpose is to strike a balance between protecting citizens against lawsuits and designed to only chill their First Amendment rights to participate in matters of public concern and the rights of persons to file meritorious lawsuits. Texas Civil Procedure 27.002 Hall, D Magazine Partners versus Rosenthal and Lipinski. A motion to dismiss under the TCPA is manifestly not intended as a means of disposing of the meritorious suits on a quick summary proceeding before evidence can be gathered and merits developed. In that, the TCPA is also designed to protect the rights of the plaintiff to file the meritorious lawsuit. Plant Services. Sorry, lurgy. All defendants argued that Vic claims are based on, related to, or in response to their exercising the right of free speech or association. The TCPA defines that the exercise of the right of free speech as a communication made in a connection of a matter of public concern, the procedure 27001. The TCPA's definition of free speech has two components. One, the exercise must be made in the communication, and two, the communication must be made in connection with a matter of public concern. Number called versus Wissenhut. A matter of public concern includes the issue related to health or safety, environmental, economic, or community well-being. Technically, this will be community well-being at this point. And not only for the anime community, but also for the Dragon Ball community and the voice acting community. The government and a public official or public figure, or a good product or service in the marketplace. Text interpretation 27017. Whether speech expresses a matter of public concern must be determined by the expression's content, form, and context. Done a Bradstreet Incorporated versus Green Marshmallows Incorporated. Oh, sorry. The mere fact that the topic relates to a public controversy does not necessarily equate with a matter of public concern. Time Incorporated versus Firestone. Rather than speech deals with matters of public concern when it can be fairly considered as relating to a matter of political, social, or other concern to the community, or as a subject to legitimate news interest, i.e., it is a subject of general interest and of the value and concern to the public. Lane versus Franks and Wolfgang versus Archer. Okay, line 60. Vic does not dispute that the defendant's tweets at issue fit with the TCPA's definition of communication. Text of civil procedure 27001. For example, prosecution of crimes and the resulting judicial procedures are matters of public concern. Brady vs. Kelsman, denied. Embarrassing facts about private citizens, however, are not matters of public concern, regardless of public interest in the subject matter. Star Telegram Incorporated versus Doe. A. Fundament's evidence and arguments fail. Funimation argues that its tweets were made in connection with public concern about health and safety or the community well-being of the anime community. However, Funimation fails to provide any evidence or argument defining its amorphous anime community. It's true. For example, does this community include every human on the planet who watches anime, or only those who attend anime conventions? That's actually quite a good question. Got a long answer in that. It's more likely the former rather than the latter. More likely both. Funimation provides no evidence or even argument, either one, identifying the community whose well-being is a matter of public concern, or two, explaining whose health and safety is a matter of public concern. Funimation also asserts that its tweets were related to a public concern about Vic as a public figure that was created by Han Leia January 2019 tweets and subsequent allegations of sexual misconduct through a negative Twitter post and other sources within the anime community. As shown, Han Leia accused Funimation of employing a pedophile, which turned out to be Irakudola, not Vic, and Vic being rude, homophobic, and creepy, but not of sexual misconduct. Han Leia's tweets do not Vince transformed into a public figure. Vince Funimation's alleged public concern about the about the allegations of sexual misconduct by Vic. Let me see one of this thing. For examples of topics that are not necessarily matters of public concern, speech solely on the individual and public interest of the speaker and its specific business audience. Dunn versus Bradstreet communications about the person's private life, Pickens versus Cordia. Disproved on other grounds by Hirsch versus Tatum. Disproved on other grounds by Dorbert versus Jevon Incorporated. And that's it. And Funimation fails to identify any negative Twitter posts and other sources within the anime community, other than posts from Poly.com and Anime News Network. Why did you put the S that time? Seriously. But these two internet posts are not conclusive. Walston versus Reader's Digest Association Incorporated. A private individual is not automatically transformed into a public figure just by becoming involved or associated with a matter that attracts public attention. Public figure fall into two categories: general purpose public figures and limited purpose figures. WFFF TV Incorporated versus Lemore. A general purpose public figure is someone who has attained such a persuasive fame or notoriety that he becomes a public figure for all purposes in all contexts. He is a well-known celebrity and his name is a household word. Gertz versus Robert Wirth Incorporated. The Born, etc. By contrast, a private individual has not accepted public office or assumed an individual role in ordering society. Gertz. Vic is not a general purpose public figure. Vic is neither an elected official nor well-known celebrity like Tom Hanks or George Clooney. The court will recall neither it nor opposing counsel can identify Vic or correctly pronounce his name at the initial hearing of this matter. Vic has testified that he is not broadly famous as a general purpose public would be. I'm trying not to fucking cough. Damn, let me go and grab another lozenge. Just bear with me a second. Alright, I'm back. Alright, let's get back to the document. Alright, these articles are admissible. See Super Section 2. Excerpts from the May 31st, 2019 hearing. While Funimation relies on Vic's Twitter followers, 119,000, and IMDb credits 432, about explaining how this conveys public figure status. Numbers alone. Yeah. Pickens considered that Dog the Pug has more Twitter followers than Vic. Someone check that! Seriously, someone check that shit. Neil, calm down. There is no reasonable assertion that Dog is a general purpose public figure. Plus, Twitter followers can be purchased. Citation 6. Undermining any argument that the number of Twitter followers is credible evidence of public figure status. As for IMDb credits, numerous people who identify well-known celebrity, name household word, say this will have more IMDb entries than Vic. Evan Bacon, 542, Best Files, 915, James Hong, 433. Indeed, IMDb, like Wikipedia, is inherently unreliable. See version 4. Whatever, say True, I could. Animal. Funimation has simply not proven that Vic is a general purpose public figure. Vic is not a limited purpose public figure. Limited purpose public figures are only public figures for a limited range of issues surrounding a particular public controversy, like more. Texas uses a three-part test to assess whether an individual is a limited purpose public figure. 1. The controversy at issue must be public, both in the sense that people are discussing it, and that people other than the immediate participants in the controversy are likely to feel the impact of its resolution. Technically, that's fine. I don't think I'm losing frames. I haven't lost frames. It's just because I'm currently got a bit of a lurgy, Optimus. So, I'm just taking my time. I think I may end up coughing up this soon. I'm like 1 foot away. Let me bring it a little bit closer now. There we go, that better? So basically, we technically be passed for that, because we are going to feel the impact. Okay, I thought so. The plaintiff must have more than trivial or tangential role in the controversy. He doesn't, so that technically fails on that. Yeah, there we go. Dog the Pug has 2.8 million followers. We also got we got sites how to buy Twitter followers. We got the IMDb pages, respectively. And 3, the alleged defamation must be germane to the plaintiff's participation in the controversy. Neely versus Wilson, however, the allegedly defamatory statement cannot be what brought the plaintiff into the public sphere. Those charged with defamations cannot, by their own conduct, create their own defense by making the claimant a public figure. Hutchinson versus Prixmore. In considering the plaintiff's role in the controversy, the court considers A. whether the plaintiff is solely sought publicity surrounding the controversy, which he hasn't, whether the plaintiff had access to the media, and 3. whether the plaintiff voluntarily engaged in activities of necessarily involve the risk of increased exposure and injury to reputation. No, no, and no. Meh. I haven't even got definitely my noise cancelling is that high. Hang on, let me turn that up on volume. That better? Let me know. Now, more? Okay, good. Funimation does not explain what behavior was alleged in the nebulous negative Twitter posts and the other sources within the anime community. Hence, this reference constitutes no evidence of public controversy. Big expectation therein of that big sort possibility surrounding the controversy. The pedophile reference in Hans' tweet was not Vic. Laying that this tweet as evidence of the public controversy involving Vic, his petition therein of that he saw the possibility surrounding the controversy. Indeed, Vic has vehemently denied engaging in the behavior alleged in the admissible Polygon.com and the Anime Network articles, undermining any argument that the articles support Nick's participation in any public controversy or that he sought policy surrounding the controversy. Hey, Monica and Jamie, aren't you doing that? Haven't you been doing that exact same thing with the Dallas news reporters? You're making it a public controversy. He's not. Good luck with that, asshats. Funimation has presented no credible evidence that Vic voluntarily engaged in activities that necessarily involve the risk of increased exposure and injury to reputation. In fact, the defendants initiated rumors about Vic long before Hanlo's tweets. Super note 7, and the defendant's behavior cannot make Vic a public figure. Nearly. Further, Funimation fails to produce any evidence that anyone other than Vic and the defenders will feel the impact of the resolution here. While Vic, like virtually every other human being in the developed world, had access to social media, he did not seek out the news media. Rather, he merely asked his supporters to publicly speak about their positive experiences with him, denied the allegations levied against him, upon trust anyone he unfortunately offended, and called for, not spurred, the immediate accession of any harassment. Contrary to those previously found to have interjected themselves into the controversy, more, Vic neither sought this controversy nor inject himself into it. Funimation preferred to prove Vic is a limited purpose figure. Actually, it's only been going on for 8 months. We're now going on to the 9th month. We're 3/4 of the year in. It's fucking hilarious. Number 3. Funimation's argument and evidence are self-defeating. Even so, Funimation claims its tweets merely stated they were parting ways with Vic after the 2nd season of Marouche Monoyoki. But Funimation fails to explain how the status of Vic's contract as of general interest of public value and public concern, Lane, and Bulknot. Moreover, Funimation fails to explain how his investigations could be related to a matter of public concern when it was confidential internal investigation. Nevertheless, if Funimation's arguments supporting the affidavit are to be believed, its tweets bear no relation whatsoever to the supposed public concerns about allegations of the sexual misconduct, because its tweets merely stated that it was parting ways with Vic, and then asked the global anime community to be kind to one another, as did Vic. Put another way, if Funimation's arguments and affidavits are to be believed, its tweets were not based on Funimation's motion, or on, or related to, or in response to the public concern about the allegations of sexual misconduct against Vic, and therefore are not subject to the TCPA. That was Funimation. We're now going into moral. B. Monica's evidence and arguments fail. For the same reasons, Monica and Ronald failed to invoke the TCPA. They argue without buttressing with evidence that it is axiomatic that the Vic claims to implicate a matter of public concern that they need to show no more. But there is their burden under the TCPA. Relying on hearsay, speculation, other immiscible testimony, they oppose that the rumors and allegations about Vic were swirling for a year. A proposition flatly rejected by a 20-year veteran anime voice actor. Monica and Ronald claim the communications Vic seeks to sons implicate the health of or safety and the well-being of the local, national, and international community of the fans who attend these conventions. They fail to explain how their comments concern such a broad category of persons. For example, how their comments concerning the health and safety and well-being anime fans in Japan. Also, they fail to identify the danger that Big presents the anamorphous group of people that they claim need to have their health and safety protected. Hey, Demi. I know, right? Further, Monica and Ronald claim that Twitter statements concerning plaintiffs' improper behavior, exasperated by his own public comments, coupled with turning shock jock loose to further fan the flames, perpetuated this controversy. Talking about Nick. Not true. The defendants initiated the rumors and fanned the flames of the allegations, their own Twitter statements calling Vic a predator and saying he sexually assaulted hundreds and thousands of people, fueled up this controversy, and indeed they began tweeting about before the online the articles on which they, Super Footnote 12, rely on published and shock jock they claim perpetuated this controversy did not comment on Vic's situation until after Monica provided her full story on Twitter. Technically true. It's been going fine. Right now I've got a bit of a lurgy. Trying to get it as fast as I can. Any controversy was created by Monica and Ronald, and they cannot use it to cloak themselves in the TCPA. C. Jamie's evidence, arguments, and fail. Jamie argues that Vic is a general purpose figure because he has a fan club and has been a voice actor for hundreds of Japanese anime films, an accurate statement, has a GoFundMe account created by a Minnesota attorney, and a particular number of Twitter followers, and because of the allegations about him are being publicly discussed, neither of which is evidence, and that he is a public figure for all purposes and all contexts, or that his name is a household word. Look at more. No. Get a shit out of. She also argues that he is a limited purpose public figure because he attracted limited media attention and concludes, without providing any evidence, that there is ample evidence in the court's record that multiple people are discussing about Vic's abuses. Vic is the center of the controversy. He injects himself directly to it and falls beyond the merely intangible or trivial role therein. Wrong! 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 You guys drug him into it. You play a tentacular role into it. He plays no role into it at all other than the victim. You ginger bitch. I'm glad apparently that Vic said he has no sexual interest in you at all. Because you're trying to look like his ex-fiancé, aren't you? Trying to make yourself look like Michelle Specht. How about you take your Valley Girl voice, Cut off your own fucking tongue and fucking eat it in chili. Hmm? And the statements of which Vic complains are directly germane to the plaintiff's participation in this controversy. Wrong. Aside from the threshold issue that Jamie has a burden of proof to establish TCPA, a possibility her arguments fail for the same reasons as Funimation's arguments, which she duplicates. Hey Funimation, can I just copy that for a second? I'll give it right back. I'm not plagiarizing you in any way. Okay, you're saying that was too far? Cutting off your own tongue and eating in chili? I think Cartman's killing the guy's parents and then putting him in chili is way worse. Ralston, Lamore, and Neely. Oh, and I probably should say this in Minecraft. Even so, Jamie claims her tweets relate not only to her own safety, yeah right, but to the safety of Vic's other past and future victims, yeah right. Vic has vehemently denied the allegation based against him, specifically the claim made by Jamie Markey. While Texas courts may recognize when the statement concerns even just individual states of safety, the TCPA applies. Jamie's statement. Wrong. Which has changed since the initially made by her. Made years after she claims it happened and is not implicating her safety in any way. She had contact with Vic multiple occasions after she claims he assaulted her, which indicates she had no concern for her safety, health, or well-being until she made her defamatory and a false statement in furtherance of a conspiracy with Monica, Ronald, and Funimation to destroy Vic's career. If she was so concerned about her safety and health, and was concerned about the safety and health of what she claims are past and future victims, why did she wait years to make her statement? She provides only self-serving statement and no other evidence to demonstrate her concern for others. Furthermore, an issue is not automatically a matter of public concern because it would become one in the future. Jun Yin Yang versus Li Chiu Hyun. Bill dismissed by Saddam. Jamie's digital argument fails. Defendant's tweets are not an exercise of protected speech. The TCPA does not protect an unfettered right of speech, but rather expressly protects the right only to the maximum extent permitted by law. Weber. Defendants have failed to prove by providence of the evidence of that the tweets are subject to the TCPA, and that the court should deny their motions on this point. 2. Vic claims do not implicate defendant's right of association. Let me get my headphones in a bit more. The exercise of the right of association means a communication between individuals who join together to collectively express, promote, pursue, or defend common interests. Texas Certification 27.0012. But the right of the association under the TCPA relates to the sorts of expressive activities that are an inherent essence of self-government. Kanawak versus Antara Rest Corporated. The common interest required in TCPA's definition of the right of association must be shared by the public at large, or at least a definable group. In 2019 WL 762108 at *8, none of the defendants provide evidence that the public at large is interested in this dispute, or that there is a definable group, other than the amorphous anime community, with whom they share interests expressed in their communications at issue. Their argument is simply incongruous with the TCPA's protections. Exactly. He is. And I met him. So, I met him. Vic can establish a primary issue case of his claims. Even if the court determines that defendants have met their burden by preponderance of the evidence, Vic can establish a primary issue case for each essential element of his claims. Number 1. Defamation. There is no controversial value in the false statements of fact, whether the intentional lie or the careless error. Good. To satisfy his burden of the establishing prima facie that Funimation defamed him, Vic must produce the minimum quantum of evidence supporting a rational inference that the following allegations are true. A defendant published a statement that defamed him, and that with the requisite a degree of fault regarding the truth of the statement and damages. Rosenbaum. Pleadings of the evidence that established the facts on when, where, and what was said, the defamatory nature of the statements, and how they damaged Vic should be sufficient to defeat the defendant's motions. Levinsky. I think I did put the Discord link in the chat. I mean, in the description. Give me a second. Remember, I'm the one that's supposed to be Steam, mate. Defamatory false statement. In making his initial determination of whether the publication is capable of defamatory meaning, the court examines the gist of the publication. Needing. The publication's gist is not based merely on the individual statements considered in a vacuum, rather individual statements, literally or substantially true, published together to convey a false or defamatory meaning. For example, by omitting or juxtaposing facts. Rosenthal. The court must consider whether the words and how they are used or are reasonably capable of defamatory meaning based on how a person of ordinary intelligence would perceive the statement as a whole. In this analysis, it is helpful to ask whether the statement published was more damaging than the truth. Weber. Yeah. Funimation's tweets, as seen as a whole through the eyes of a person of ordinary intelligence, declares that their investigation determined that Vic engaged in abusive and harassing conduct. Was this the interpretation by those following Funimation on Twitter? Funimation claims that it was not intended and that it included that there was inappropriate conduct. That the conduct was, but Funimation does not say. Excellent. However, none of Funimation's affidavits claim the investigation concluded Vic had engaged in abuse or harassment. Indeed, according to Vic, Funimation's vague investigation only asked him about eating a jelly bean, which one of our future medic convention, not Funimation's officers, flirting with two adult women at the convention, the Yost twins. Hello there. Welcome to the stream. But right now, currently got a bit of a lurgy. Currently got a bit of a sore throat. Maybe developing a cold. But slowly trying to get him as quick as possible. Who had been flirting with him for more than a year and a single consensual kiss with a co-worker at Funimation's offices. There was no allegation of abuse or harassment. At this state of the case, the court presumes the truth of Vic's assertions, and that there is certainly nothing abusive or harassing about his conduct. Before Funimation's tweet, Vic had publicly denied the allegations of harassment or abusive or inappropriate conduct, and denied directly to Funimation the allegations of inappropriate conduct, on which it now relies. At this phase, this is direct evidence that Funimation's tweets are false. Ferdinand versus Khan, which ended not that long ago. Oh, just trying to swap everything out. Monica claimed that Vic assaulted her and others and that he's a sexual predator, and that apparently he's a legal definition of harassment. Which I think she did. She also told Slate Judge that Vic would be criminally charged. Jamie also tweeted that he assaulted her and others. This is defamation per se. Pinsky. Vic publicly denied their allegations, and publicly denied Monica's allegation in his email to her, and has denied them in his deposition and his affidavit. Oh. The video goes for a little bit longer. Since only they actually know the truth. Only they and Vic know the truth of their allegations of assault, Vic's denials are sufficient to establish the falsity of her statement. For on stand down and refuted Monica's description of the events, which with further evidence of the falsity of the statement. Carl. Oh, sorry. Ronald's defamatory statements. It's just coming a sore throat at the moment.
Hi.
Hello, now you're on my stream.
Oh, cool.
Either way. Ugh.
I mean, at least it worked out.
Yeah, at least.
Because I have to turn down the volume.
Sorry, yeah, you may need to mute that. Yeah, cause right now what? Well, I'm only on page 25, and there's 1,188 pages.
I was watching your stream, then I saw Jay post that there's VC, so I just left the stream.
Ugh.
And now I'm in the stream again.
Yeah.
My.
Okay. Ronald's defamatory statements. Ronald repeatedly tweeted that Vic had assaulted Monica, and that he knew at least 3 others whom Vic had assaulted, and knew 100 other women were going to come forward to accuse Vic of sexual assault. That Vic was a predator, and that Vic would be a registered sex offender. Moreover, he told Slatosh that Vic would be criminally charged. This is defamation per se. Lipinski. Vic publicly denied his allegations and has denied them in his deposition and his affidavit. And Ronald testified that he based his knowing that 100 other women were coming forward on internet posts he did not verify. Again, in this phase, these are enough facts to establish the rational inference that Vic's allegations are true. Don't you mean false there? I think he means false.
I actually haven't been following the lawsuit since, like, what was it? I think maybe in February. I kind of give up after that. I'm just like, okay.
Yeah. The court date's like in 6 days.
Oh my goodness. Wait,
This
in 6 days?
Yeah, this is for something known as the TCPA, which is known as the Texas Civil Procedure Participation Act. Basically, anti-slap. Basically, they're saying it's free speech, Vic's a public figure.
Mm-hmm.
This is Ty's rebuttal to all of it. And this has more pages than Stephen King's It.
How many pages did you say it was?
1,188.
Dang. How thick?
Yes. Fun enough, I want to go see It Chapter 2. So.
Same.
Ugh.
I guess that means.
Yo, but the original one?
Video.
I know the original one just got re-released with 8 minutes of extra footage for the next movie.
Oh my gosh. Yo, but the original one, look, I love, the It that just came out recently. It was pretty good. But the original was, like, so hilarious. Like, I remember being scared of it, like, when I was little. But, like, as an adult, it's, like, I just got my humor all fucked up and everything, and I just like started laughing throughout the whole film.
I probably never admitted this before. I used to be creeped out by Tim Curry dressed up as Pennywise. This was like 19 fucking years ago. And now I'm not scared of him, and I look at Bill Skarsgård like, good shit.
My favorite part is the library scene. That shit was funny.
Ugh. Okay. Prerequisite. Carry on.
I was gonna say the only thing that really creeped me out from the original was the part with the old lady and what's her face, the girl.
Oh, Beth and Mrs. Kirsch.
Yeah.
Yeah. Yeah. That scene's gonna get a bit more weirder in in the next one.
Oh my goodness! I saw the not commercial, but the trailer.
Yeah.
Yeah.
Yeah, you saw the naked old lady.
Oh my god.
Trust me.
But hey, just
Yeah, if you look behind, not focus at Beth, but focus where the kitchen is, because it's commonly dark there. You see the little old lady dancing butt naked.
Oh my god. Hang on, I have this one GIF of Pennywise, or not a GIF, but probably like this picture, and it was so funny when I saw it. I started laughing my ass off. Hang on.
No, don't. No, don't. Huey, if you are in the chat, please state your age when you can, please. I don't like to keep people. Give me chungus.
Where is your stream anyway?
Let me a second. Let me actually fucking link that shit. Because right now I just put down the Beard Responds. Makes sense. Why do I link it at?
Oh, in the server? Just open to public. It's like right there.
Yeah. Oh, no, that's my Discord. And, okay. There we go. Copy link address. Paste. There we go. The Beard Responds. Yeah. My logo's getting out of it. Right. I probably should also mention who these guys are. This is Seijay, who's going to be the voice of Kid Goku for the Dragon Ball Z GT Abridged. So, and of course, because I'm going to be Pan, so we're going to be working quite a lot together.
Awesome.
And of course, Drew, I think you're one of the writers, and Vegito?
I'm not a writer.
Lord Donkey.
Yeah, I'm that weird guy. That's the best way to describe them.
Oh, rip. There we go.
Maybe side characters if I'm lucky. That's mostly it.
Oof. Good stuff.
I'm not a main character person, to be honest. That's not where my talents rely. They rely on those weird characters you don't remember, and I try to make them memorable.
Exactly.
Yeah, definitely.
Oh, you're streaming the thingy. Right.
Yeah. So I would probably suggest mute the stream. So I think that may be a bit of a delay.
I mean, I did.
Yeah. Okay. Requisite degree of fault. Vic is a private, not a public figure. Hence, he need only prove negligence. Levinsky. He denied the defendant's allegations against him, and the charge of pedophilia was determined in 2014 to be someone else, Eric Gorola. This is sufficient factual basis for a rational inference that Vic's allegations are true, that all defendants treated the charges against Vic of assault, abuse, and harassment with negligent disregard for the truth. Oh, there's only like 35 pages, and the rest is just all debunk shit. Love it. I just read the fucking bottom.
Yo, look, I think I can't remember where I saw this. I know it was on Twitter. I know Monica Real said something about the case being dismissed. I'm not sure if that's true or not, but that was something that I saw.
No, it doesn't. It won't get dismissed until Friday. But
Okay.
Friday's the turning point.
Okay.
So I think she's saying a little fib there. Monica, why are you lying? I met you 3 times. Come on. Get your head out your own ass. Sorry for my callous language. Normally this is not how Pan should act.
Yo, I was gonna try to go for like a cowboy accent for Pan, but oh well. That's all right.
Well, technically Pan's kind of close to my Caligula, it's just less attitude.
Yeah.
We have 18 minutes of fucking audition recording, doing several different tones. Okay. Even if the court determines Vic is a public figure and the defendant's tweets were in response to a matter of public concern, all defendants acted with malice. For defamation claims, malice means the defamatory statement was published with knowledge that it was false or the reckless disregard of whether or not it was true or not. Reckless disregard means that the publisher undoubtedly doubted the truth of his publication. For example, accusing the plaintiff of a crime he did not commit. Weber. Regardless, disregard may be shown by substantial evidence as well as by showing the publishers purposefully avoided the truth. The information that Vic gave Funimation during this investigation confirmed that there was no abusive or harassing behavior and that it was sufficient to give Funimation serious concern about the truth of his statements prior to tweeting. Indeed, he had already publicly denied an allegations of wrongdoing, and Funimation does not claim its investigation identified any abusive or harassing behavior. Moreover, Mars Girl showed that the underage sexual assault story was not about Vic, a fact established in 2014. Viewed in this light, most favorable to Vic and drawing reasonable inferences in his favor. Either Funimation purposefully avoided the truth, or in the information coupled with Vic's version constitutes the circumstantial evidence that Funimation had serious concern about the truth of his statements. Vic denied Monica, Jamie's, and Ron's claims at this stage of the case that this is sufficiently established that they knew their statements were false, and thus the elements of malice gone. Also, Ron identified that he had no personal knowledge that hundreds of women coming forth. He also testified that no matter what he believed the anonymous stories of the internet, he saw Vic's video denial, but he persistently avoided the truth. That hurt my tongue. But then again, trying to actually do the fast bar rap chord even hurts more. Lol. Damages and all defendants. When publication qualifies as defamation per se, actual damage is not an essential element of the claim to which the TCPA's burden to clear the specific evidence applies. Levinsky. The defendants accusing Vic of abuse, assault, harassment, predatory behavior, being a monster, and being the legal definition of harassment and accosting underage girls is defamation per se. Accusing someone of a crime and allegation of sexual conduct is defamation per se. Moreover, the defendant's defamation or cancellation of Vic's invitations and contracts to appear at conventions, Weber, 15. A statement that injures a person in his profession or occupation is typically defamation per se, and the defendants caused Vic actual damages in lost income because conventions cancelled his appearances due to their defamatory tweets. Is it wrong to ask a girl who's a year older than you? Well, the guy that I'm currently bunking with, who's currently considered my best friend, is 12 years older than me. Is that creepy? Would you find that to be creepy?
No, if it's only 1 year, it's no.
It's 12.
Wait, what?
He's 12 years older than me. I'm 27.
Oh.
I'm legal. I would have thought. Well, technically, you have to go by the age, halve it, and then plus 5 years in order for it not to sound creepy. Yeah. So I'm good. Okay, they can establish a prima facie case of tortious interference. Tortious interference with contract and a prospective contract. To satisfy his burden of establishing a prima facie case of tortious interference with a contract, Vic must produce the minimum quantum of evidence supporting a rational inference that the following allegations are true. He had a contract, and the defendant knowingly and intentionally interfered with this contract, causing an actual breach is not necessary. The interference was approximate cause of his damages and the actual damage. Cuba versus Plate. To satisfy his burden of establishing a prima facie case for the tortious interference with possessive business relations, a plaintiff must establish a reasonable probability that the plaintiff would have entered a business relationship with the third party. The defendant acted in a conscious desire to prevent the relationship from occurring, or knew the interference was certain or was damagingly certain to occur as a result of its conduct. The defendant's conduct was independently torturous or unlawful. The defendant's interference approximately caused the plaintiff's injury, and result of the plaintiff suffered actual damage or loss. Day versus Federation of State and Medical Boards of the United States Incorporated. Cuba, Slaytosh, and Vic all testified that the defendants knew of his agreements with cons and conventions from cons. Approached conventions to cancel or do not do business with Vic and succeeded. Vic and Slaytosh both testified to actual damages Vic suffered. Oh!
Chuck Hubbard. Chuck Hubbard. Chuck Hubbard testified?
Chuck Huber, yeah. Yeah, he has an affidavit.
I don't know why I said Hubbard. I'm sorry. I mangled his name.
Yeah, it's Huber. Because I know he's going to be at SailCon, so it would be great to meet him. I need to get an Android 17 pop vinyl.
Is Chuck Huber following you on Twitter? He just started following me.
He hasn't, no. I know Peter Calamus does, because he likes me. He likes me. I know he does.
Awesome. Awesome.
And apparently I've been kicked off Twitter. I mean, signed out, not actually kicked off Twitter. Oh, Stan Don just tweeted. Know that at least one VA who dated a number of other VAs and a fun employee. I've met those VAs and that employee. Actually, I'm not sure if that employee worked for Funny or Okatron. Or both. Oh. Sorry, but you can't see my smile right now. It's like that little Cheshire little smile that Chris Pratt did.
Yeah. From Parks and Recreation, right? Wait, or was it some other? Parks and Recreation. Shit's funny.
I don't know, but either way. Well, I mean, this is one that actually has a folder. Well, everyone's on my desktop for a second. Don't worry, there's nothing rude here. Just Warframe shit.
Magic Zine in the chat. He's like, when I saw how many pages there were.
Yeah. There's.
Yeah.
Too many.
I need that reaction image. I'm gonna steal it.
Okay. Vic can establish prima facie case of conspiracy. To satisfy his burden of establishing a prima facie case of civil conspiracy with a contract. Oh, pardon me. Vic must produce a quantum of evidence supporting the rational inference that the following allegations are true. Information and at least one other person. How about 38? 38 voice actors in on it. in on the conspiracy.
Interesting. Interesting.
I've been doing the head count, so I've been keeping an eye on everyone. I'm like, 38? Who's next? 39. Because I'm getting you.
Getting you. No. I can't do Getting You's voice, no.
Okay. Had an object to be accomplished in a meeting of minds on the object or course of action, and engaged in one or more unlawful overt acts, and Vic was damaged as a proximate result. Argo Corp Incorporated versus Electoral Circus International LLC versus United Pentecostal Church of Beaumont versus Parker. Conspiracy often must be proven by circumstantial evidence. The evidence shows the defendant's objective here was simple: run Vic out of Funimation, ruin his reputation, getting kicked out of Funimation, i.e. #Get Vic. Marchie signaled the plan: the best way to ruin his career is to name and shame. Monica initiated Funimation's internal investigation, and Funimation shared details with Monica and Ronald that they publicly goaded Funimation to release the contents of this investigation while bombarding Vic with defamatory tweets. Meanwhile, despite Funimation's argument that she had no authority to speak for the company, Monica and several other Funimation's employees, whom she is very good friends, emailed back and forth about the investigation and how to make Monica feel better and what it could say to the Monica say to the public. Even Marky tweeted about the investigation, seeing and Really? Thanks. Even Marky tweeted about the investigation, seeing conventions cancelled after Monica's tweets of Hanley's false and retweet of false accusations by Hanley. Funimation tweeted its defamatory statement and it was parting ways with Vic after this investigation because of abusive and harassing behavior. Monica then tweeted her endorsement of Funimation investigation, and Ronald tweeted gleefully that Vic's career was over. Mission accomplished. Funimation has stood by Jamie, Monica, and Ronald, exposing themselves to damages, fulfilling its part of a conspiracy by lending credence to Monica and Jamie's allegations. They have played their role in a sine qua non of the conspiracy. Vic can establish a Funimation's case of vicarious liability. Monica's email with Funimation shows they exercise control that she could say in a public arena, and by virtue of her friendship with Ronald, over him as well. While Jamie claims that she is the invented contractor, her legal conclusion that Funimation has no control over her is unfounded and inadmissible. Perhaps most damning, Funimation never only once stated publicly that Monica, Ron, and Jamie did not speak for Funimation, but only expressed their own opinions. The international firms Monica, Ron, and Jamie had inside information and the authority to speak for Funimation. Defendants failed to establish their affirmative defenses. I know, right? In defendants, Monica Rial and Ron Toya's motions dismissed pursuant to the Texas Civilization Petition that there are two affirmative defenses listed: qualified privilege and liable proof. In Funimation's supplemental brief in support of its TCPA motion, which Vic objects due to its being filed outside the TCPA deadline, Funimation adds the affirmative defense alleging that Vic is liable proof under the Texas Civilization Petition Code 27.005D. The court should dismiss a lawsuit if the moving party establishes by the proponents of the evidence essential and the evidence of a valid defense of the non-movement's claim. See Bian versus Fort Worth Star Telegram. Sweet Schaefer's. The court should not dismiss this lawsuit because the defendants are unable to prove the abundant evidence which is essential element of the affirmative defense that they claim. Qualified privilege. The defendants to prevail on affirmative defenses for qualified privilege must show the statements were made without malice, The statements concerned a subject or a matter of interest to the author and was inference to a duty owed by the authors. And 3. The statements communicated but to another party with corresponding interest or duty. Bryant versus Lieutenant Services Incorporated. Statements made without malice. Malice means that a statement was published with the knowledge that it was false or the register to disregard and whether it was true or not. Lipsky. Reckless disregard means publisher doubted the truth of his publication, but his disregard may be shown as substantial evidence as well as by showing the publisher repeatedly avoided the truth. Weber. Defendants claim because Montoya was aware of multiple allegations against Vic, and because there were articles written about Vic with the statements by individuals, that his over 300 statements are not only true, but they were made without malice. And the multiple allegations the defendants are claiming involve 4 people who are involved in the defamation investigation. Vic has denied the allegation made by the 3 people, including Monica Rial, and it's evident that the kiss between he and the former information employee was consensual. Who was Sarah Buckmeyer? We already figured that out.
How did you figure that out?
Kiwi Farms.
Oh.
They're good. They are incredibly good lip readers.
Yeah, look, Kiwi Farms. They go in the dark web to dig up some stuff.
I know. The thing is, that was easy. Lip reading is pretty much easy. And also the Yost twins. They got them too. Hilarious. The allegations made against Vic by Monica Rial are clearly false and not only based upon the Vic's denial and affidavit, based upon the affidavit of Stan Darlan, the person Monica Rial has claimed to verify her story. Monica Rial and Ron Toye were aware the statements they were making about Vic were false at the time, and they made them with reckless disregard of the truth. Therefore, Monica Rial and Ron Toye appear to be using the Seinfeld defense, which is, it is not a lie if you believe it to be true. Well, also, I can quote Winston Churchill, a lie can get halfway around the world before the truth can even put his pants on. The misplaced use of this defense further bolsters the fact that their statements were made with malice and thus qualified privilege does not apply and Vic lawsuit should not be dismissed. Hey, Curtis. Let me just open this chocobo.
Kratos. I think I've seen him before. Kratos. Oh yeah, God of War.
What kind of ticked off? Boy.
Why you ticked off?
That's it, no. Thank you for the 5 bits, what if. Thank you. Oh, thanks a lot.
I had them and I didn't know, so I just gave them.
Scoops,
It was like,
scoops,
okay,
scoops, scoops. Lol. Fun. Oh, I need to add my tip jar again. When I had the tip jar, this was like back in my Dokkan days, I turned all the bits into the dragon stones.
That's cool.
It was funny. Haven't done that since. I really need to get back into it.
Oh yeah.
Okay. Statements concerned a matter of sufficient interest to the author or was in reference to a duty owed by the author. Defendants claim that Monica Rial and Ron Toye had an interest in the Funimation investigation and its results because Monica Rial was the person assaulted, which was debunked by Vic Stannard and Stan Darlan's affidavit, and Ron Toye is her fiancé. Monica Rial and Ron Toye had no interest in Vic being terminated by Funimation. Vic being terminated by Funimation had no financial or legal or moral implication for either of them, and thus had no interest to discuss the investigation or Vic's termination. Monica Rial was under no duty to discuss Vic's termination by Funimation. In fact, in emails with Funimation, she asked for direction about what she could discuss, thus telling her story she had nothing to do with Funimation's investigation or subsequent termination of Vic. Ron Toye was under no duty to discuss Funimation's termination with Vic either. For these reasons, Montgomery and Montoya's claim that the statements are concerned in a matter of sufficient interest, or that the duty is to discuss Vic's determination by defamation fail, and the court should not dismiss Vic's lawsuit. Statements were communicated to another party with corresponding interest or duty. Defendants do not address that the statements were made or communicated by another party with the corresponding interest. They simply assert that they had to defend themselves from the attack online. Nothing provided by them to explain how calling Vic a predator and accusing Vic of sexual assault against hundreds and thousands of people was communicated to another party with corresponding interest or duty. Thus, qualified privilege does not apply, and Vic's lawsuit should not be dismissed.
You're almost there. You're almost at 35.
So, yeah, and then I'm probably gonna have to read the affidavits. And we'll have a gander through the other stuff. For defendants to prevail on the affirmative defense that Vic is libel-proof, they must show 1. The plaintiff engaged in antisocial or criminal behavior in the past, and 2. His activities are widely reported to the public. Bride versus Newbuntsford Herald, Zontic. Libel-proof plaintiff is one whose reputation on the matter in the issue is so diminished that at a time of otherwise libelous publication, it could not be further damaged when invoked. That the doctrine bars the plaintiff from presenting his claim liable to jury. Yeah, he's not libel-proof. He's still getting money. He's still got fans. Crock of shit. The libel-proof doctrine should have only limited application, as there are few impure that cannot be truants, while a person's general reputation may be so bad as to render him libel-proof on all matters. Ordinarily, even public outcasts remaining in good reputation is entitled to protection. Van Keller versus Jacksonville Daily. Defendants who would have this court believe that Vic's reputation was so diminished at the time that they made the false statements that his reputation could not be further damaged. However, prior to the defamatory statements of the defendants, Vic was employed and attended the convention. After the defamatory statements, Vic's 20-plus career was in doubt, and he had 10 conventions cancel his appearances. 10 convention cancel his appearances. Vic's reputation did not and does not render him libel-proof. Plaintiff engaged in antisocial or criminal behavior in the past. Defendants allege that Vic is libel-proof based upon the defamatory articles, and his own admissions of the rumors of pedophilia have followed him for years. Defendants do not demonstrate how Vic engaged in antisocial or criminal behavior in the past in any way. They have provided no criminal history or police reports to show that Vic engaged in criminal behavior. Instead, they rely on supposed rumors as the basis of their claim is Vic is libel-proof. Furthermore, for some defamatory articles, they claim that make Vic libel-proof were published after Vic was terminated by defamation and after the defamatories were made by Monica and Montoya, thereby debunking their own claim that Vic is libel-proof. Since the defendants cannot prove that Vic engaged in criminal behavior, the affirmative defense that Vic is libel-proof fails. Let's go, Adventure. Hi.
Hello.
There we are. Plaintiffs. Oh, we're nearly there. Plaintiffs' activities were widely reported to the public. Defendants rely upon Sweet and Shivers as the basis of the claim that Vic is libel-proof. Unlike Sweet, Vic has not been a target of extensive negative media attention for 10 years. Defendants are unable to point a single negative news article published about Vic prior to the defamatory articles cited in the motions to dismiss. Complaints about Vic on the site is not demonstrative of his activities being widely reported to the public. Had Vic's activities been widely reported to the public, the court, as well as opposing counsel, would have known who he was and how to pronounce his name at the first hearing. Thus, the defendants are unable to prove that Vic is liable by a preponderance of evidence. conclusion, and prayer. Wherefore, plaintiffs request that the court sustain his objections, strike the Fundation's evidence as discussed above, deny Fundation's motion, and award him with such relief to which he is entitled at law or equity. Plaintiff prays for general relief. Tie Beard. Pastor Carey, Jimmy Bullock, etc. Oh.
Oh, there we go.
And that's the lot. That's something in the last page. And their motion to strike. I am okay. This one's 13 pages. Yeah, he's staying lazy. Yeah, he's staying lazy, officer. But they haven't actually fucked yet. As far as I'm aware. They tried doing that. Apparently, Quinn's lazy, and this is her truth. Her parents don't exactly like Coy. That's all I know. And that is technically a partial truth. I'm not giving the full fact. Plaintiff's objections to the motion to strike. Evidence of offers in support of the defendant's motion to dismiss, and defendant's supplemental evidence filed and reports defendant's TCA motions to dismiss and supplemental. The Honourable Judge of the Court, Plaintiff Victor Mignogna, objects to and requests that the court strike the following evidence of defendants Monica Rial and 120 have offered in their motion to dismiss under the TCPA, in their motion to dismiss, supplement, as well as the following evidence in the defendant's Defamation LLC and supplemental beliefs in support of its TCPA motion, and supplemental evidence in support of its TCPA motion to dismiss. Background. Yeah, Coy is lazy. The defendant's motion to dismiss asked the court to dismiss the plaintiff's claims under the Texas spelled TCPA. The TCPA requires that each defendant show the preponderance of evidence presented and that the plaintiff's claims are based on, relate to, or in response to the defendant's exercise of the right of free speech to petition or of association. Of 2705B, under the preponderance of evidence standard, the fact finder must determine whether or not the movements of the events are more likely than not true. Lipsky. Hence, the admissibility of each defendant's evidence is a threshold question for the court. I like how you guys are all bitching about Coy. Really?
Coy hurt me. Oh my god.
Oh my god, are you really? Or are you fucking with me? By that giggle, yeah, you're fucking with me.
Yeah. No, I was just making a voice. I wasn't actually,
Good.
saying that.
Cause I'm like, evidence.
No. I don't even know who that is.
Oh good, you don't know who Color the Cloud is.
Yeah.
I bet now he's watching the stream going, really? Yes, I am nearly 100,000 subscribers and you don't know who I am? Someone clip that! Literally, someone clip that and send it to Coy. Cause that would probably be the exact same thing that would be running through his mind. Coy, you're welcome. Okay. Objections to Rial and Toya motion. Hang on, let me go over this for a second. There we go. Exhibits attached to the deposition of Victor Mignogna. Plaintiff objects to exhibits 1 for the 13, 15 for 18, and 22 attached to Exhibit A of Rial and Toya motion. These exhibits are hearsay as to devour out the court statements offered to prove truth of the matter asserted. Hearsay is admissible by the Texas Rules of Evidence 801 and 802. Yeah, I probably should mention Coy's a whore. Even though he's got a girlfriend, he's a bit of a whore.
He a man thought?
Yeah, he a man thought. But we call him a sloot. So. Right, okay. Gated it. Everyone, go to Twitter at Coy McLeod and vote Aren't You Into It also. Just for shits and giggles. Everyone can see what I'm typing right now. There we go. Hashtag manfault. Tweet it at him! He's gonna realise what the fuck just happened!
What's his Twitter handle?
Coy McLeod.
With a K?
Yes.
Coy, buddy! You're a man whore!
I just said hashtag manfault. Yes! This video any time that I actually get to coerce harassment, but thing is, it's funny harassment. He's like, excuse me, what? I'm just gonna keep saying it. Just do it. Just do it. He's gonna realise streaming soon and be like, oh, you're fucking streaming this, aren't you? Yep. He's also a sore loser in Xenoverse. He's gonna go to you going, who the fuck are you?
I see some of it. I looked him up on Twitter. Doesn't he do Goku Black?
Yeah, he does Rose Goku Black.
Oh, love Goku Black.
Whereas I tend to do more Caulifla, so. But
Nice.
I am bringing another variation of Caulifla to the com. I am bringing the very first Super Saiyan 2 Caulifla Black.
Ooh.
So, my own little spin on it. Because I got black Karen pants, I got a grey tube top, and I'm going to wear a previously black jacket from another cosplay, which will also fit with design.
Oh yeah. That's gonna look great. That's gonna look badass.
Lol. Well, we just saw a guy just jump over his head, jump over MJ's head. Lol. Okay. Exhibit B. Affidavit of Robin Michelle Blankenship McConnell. Can you have not much of a longer name? Bruh. Plaintiff objects to Exhibit B because it's not relevant or material to any issue in this case. Texas Rule of Evidence 401. Evidence is not relevant or always admissible. 402. Plaintiff objects to Exhibit B because it contains evidence of plaintiff's character traits, his purported sexual harassment / assault of a female. That has been offered to prove that on a particular occasion the person acted in accordance with the character or trait, his purported sexual harassment and assault of a female, and evidence is admissible. 404. Just keep spamming it. Plaintiff objects to Exhibit C because it contains evidence of plaintiff's character trait. It is purported sexual harassment, assault female. That being offered to prove that on a particular association, the person acted in accordance with character or trait. It is purported sexual harassment and assault toward a female. With evidence in the admissible Texas Rule of Evidence 404, plaintiff objects to paragraphs 2, 3, 4, 5, 6, 7, 10, 11, 12, 14, 16, 17, 18, 20, 21, and 23. Because they contain admissible opinion testimony in violation of Texas Rule and Evidence 701, and because they contain unsubstantiated opinions and unliteral subjective determinations of facts statements that cannot be unreadily converted by opposing parties. Plaintiff objects to paragraphs 14, 17, 18, and the exhibits attached to the exhibit because they contain hearsay, out-of-court statements offered to prove truth of the matter asserted. Texas Rule of Evidence 801, hearsay is admissible 802. Exhibit D. Affidavit of Jennifer Lynn Hunt. You probably heard me right, Jay. I nearly said the other one, but I didn't. And what if you're still up?
I am back from the restroom.
Alright. That happened.
He's not trying to say screw up, you crazy being like mad fault. Oh, we're gonna go through that. I know. Okay. Exhibit D. Affidavit of Jennifer Lynn Hunt. Plaintiff objects to Exhibit D because it contains evidence of plaintiff's character or traits. His obsession reported sexual harassment, assault, temper tantrums, and rudeness. That has been offered to prove that on a particular occasion that a person acted in accordance with the character or the trait is purported sexual harassment / sexual assault. Such evidence is admissible in Texas Rule of Evidence 404. Plaintiff objects to paragraphs 2 through to 10 because they contain admissible opinion testimony in violation of the Texas Rule and Evidence 701 because they contain substantial opinions or unliteral subjective determinations of facts and statements that cannot be readily converted by opposing parties. Plaintiff objects to paragraphs 5, 6, 7, 9, and 10 because they contain hearsay. Medical statements would provide the truth and the matter was asserted. Texas Rule of Evidence 801, history is admissible 802. Hey Aubrey! We're going through a fucking big document. I've just finished one filing. I'm now on to the second. I'm going to cry. I'm going to go in a corner and cry and so that you might sleep tonight. Because by the time I finish this filing, I'm going to literally say, it felt like I was actually reading it. Before I can go see it. Chapter 2. Exhibit E. Affidavit of Pascal Ahmed. Plaintiff objects to Exhibit E that it contains the evidence of plaintiff's character traits, his purported sexual harassment, assault, temper tantrums, and rudeness, that has been offered to prove that in a particular association the person acted in accordance with the character or trait, his purported sexual harassment or / sexual assault. Such evidence is admissible Texas Rule of Evidence 404, plaintiff objects to paragraphs 3 to 7. They contain admissible opinion testimony in violation of Texas Rule 701, and they contain substantiated opinions and unliteral subjective determinations of the facts and statements that cannot be readily converted by opposing parties. Plaintiff objects to paragraphs 3 to 7 because they contain hearsay and court statements of the body of truth and matter asserted. Texas rule submitted to Beard 01. History is admissible in 02. Plaintiff rejects the paragraph 4 because it has been contradicted by the affidavit of Erica McCord. Take that, bitch!
Huh. Exhibit F.
Affidavit of Mary Reese. Plaintiff rejects the of Exhibit F that contains the evidence of plaintiff's character traits. His reported sexual harassment, assault behavior, temperature, and rudeness have been offered to prove that a particular association of the person acted in accordance with their character or trait is purported sexual harassment or sexual assault. Such evidence is admissible. Texas Rule of Evidence 404. The plaintiff rejects the paragraphs 3 to 15 and 17 because they contain admissible opinion testimony in violation of the Texas Rule of Citation 701 because they contain substantiated on literal and accepted determinations of the fact and evidence that can be readily converted by opposing parties. Plaintiff objects to paragraphs 8 through 11 because they contain hearsay. Adequate statements offered to provide truth on a matter of certain. Texas Rule of Evidence 801. Hearsay is admissible. Yes, Texas Rule of Evidence 802. And now Public Coy's going fucking ballistic. Okay, Exhibit G. Affidavit of Whitney Farber. Plaintiff objects to Exhibit G, which contains the evidence of plaintiff's character or traits, his purported sexual harassment, assault, temper tantrums, and rudeness, that had been offered to prove that on a particular occasion that the person acted in accordance with the character or trait, his purported sexual harassment, /sexual assault. Such evidence is admissible. Texas Rule 404. Plaintiff objects to paragraphs 3 through to 10 because they contain admissible opinion and testimony in violation of 701 because they contain substantiated opinions and unliteral subjective determinations on fact/statements that can be readily converted by opposing parties. Plaintiff objects to paragraphs 8 and 9 because they contain hearsay. 801. Hearsay is admissible. 802.
Hey, Insanes.
Yes?
My brother's here is visiting, so I'm gonna have to head off for now.
That's fine.
Alrighty. Well, thanks for having me on.
No problem.
See you guys.
Later. Okay. And the chocolate's probably more than that fucking lozenge. Plaintiff objects to Exhibit H because it contains evidence of plaintiff's character traits, his purported sexual harassment, temper tantrums, and rudeness that has been offered to prove them in particular association that a person acted in accordance with the character or trait, his purported sexual harassment / sexual assault. Such evidence is admissible. 404. Plaintiff objects to paragraphs 3 to 4 because they contain a admissible opinion in testimony in violation 701 and they contain substantiated opinions or unliteral subjective determinations of facts and statements that cannot be readily converted by opposing parties. Plaintiff rejects to paragraphs 3 and 4 and 5 because they contain hearsay 801 and hearsay is admissible 802. I know. Exhibit H. Affidavit of Anicia Perry. Again, I haven't had the time. You're on Twitch. Sword! Give me a second, I have to actually go to Twitch.
Okay.
Sorry, not you.
No, you're in chat. I just cut up. tired.
That's fun.
I don't carry eating potatoes, chat person.
Don't worry, it's Jinxie.
Oh, okay.
She's crazy. Fucking measles! There we go. You're now modded, okay? Even though there's only like one other person on the Twitch side, but that's about it.
I mean, you could give it to me if you want. I don't carry them.
Alright, let's continue on. Okay! Jinxie, can you stop having an orgasm for just a second?
Can you quit rubbing your sword?
Phrasing.
This is better than one of my shows.
Oh, no! Don't, no! Don't, Brandon! Is he really going for that?
No,
Oh.
I'm not gonna sword you.
Oh, God. Oh. Right. Let's carry on with this. Affidavit and Perry. Plaintiff objects to Exhibit H, which contains the evidence of plaintiff's character or traits. His purported sexual harassment, assault, temper tantrums, and rudeness. That has been offered to prove that in a particular occasion that the person acted in accordance with the character or trait is purported sexual harassment or sexual assault. Such evidence is admissible. Texas Rule 404. Plaintiff objects to paragraphs 3 and 4 because they contain a mistaken opinion and testimony in violation 701, and because they contain substantiated opinions and unnatural, subjective determinations of the fact statements that can't be rightly converted by opposing parties. Plaintiff objects to paragraphs 4, 8, and 5 because they contain